Can everybody hear me? Can everybody hear me? Yes. Okay, we're going to get started. We just have a couple people joining, so. Good afternoon, everybody. Welcome to the Domestic Violence Criminal Justice Response and Enhancement Advisory Council meeting for July. I am just going to start by calling the meeting to order and asking the members just to go around and do a round of welcome and introductions for attendance purposes. So I will start. My name is Megan Scanlon. I'm one of the co-chairs of the DV Council, and I'm going to move in the room first, and then I'll go virtually. So I'm going to move to Gail.
Good afternoon, everyone. My name is Gail Hardy, and I am the designee for the Chief State's Attorney. Also with me today is our recently appointed Deputy Chief State's Attorney, Lisa D'Angelo, and she's sitting over in the audience.
Welcome.
Thank you.
Hi, everyone. I'm Joe DeTuno. I'm the Director of Family Services, part of Connecticut's Judicial Branch.
Good afternoon, Merritt LaJoy, the Complaint Officer for the Office of the Victim Advocate.
Good afternoon. I'm Ginger Wilkes, Senior Director of Reentry Services for CRJ, Community Resources for Justice.
Good afternoon, Johanna Canning, Designee of the Office of the Chief Public Defender.
Good afternoon, all. Alaric Fox from the Enfield Police Department. I serve as the Chief of Police.
Good afternoon. Erin Foley O'Connor, Executive Director of the Network Against Domestic Abuse.
Great, thank you. I'm going to move to the folks online. Just starting with Shauna, you're the first box.
Good afternoon, everyone. Shauna Harrington, Director of Legal Advocacy at CCADB.
Nancy.
Good afternoon, everybody. Nancy Tyler. I am the survivor representative on behalf of CCADV.
Chief Rosado.
Good afternoon, Rob Rosado, Chief of Police, Meriden Police Department.
Phyllis.
Yes, good afternoon. Phyllis DeCara, attorney in private practice and the governor's appointee.
Ms. Garcia.
Good afternoon, everyone. Eulalia Garcia, Commissioner Quiros' designee with the Department of Correction.
Andrea.
Good afternoon, Andrea O'Connor. I'm the Family Violence Victim Advocate Program Manager with the Umbrella Center for Domestic Violence Services.
Great. Officer Maynard.
Good afternoon, Captain Ryan Maynard, Connecticut State Police.
Okay, and I think we had State Representative Jen Leeper just join. If you could just introduce yourself.
Hi, State Rep Jen Leeper. Sorry, I'm a few minutes late.
No problem. Welcome. And I think we have one other that joined. Apologies, Ms. Sullivan.
Yes, I'm just here observing. Thank you.
Okay.
We have a representative there. Joanna Canning will be there.
Okay, great. Awesome.
Thank you.
Okay. And I'm sorry, I'm just going to go back to the room for a second for those on Zoom, because we did have one of our other legislators just join. State Representative Nuccio, you want to?
Sorry for being late. Representative Tammy Nuccio, governor appointee.
Great, thank you. I think I got everybody. I am just actually going to turn really quick for those in the room and online. we do have a number of CCADV staff that many of you probably know, but I am going to have them just introduce themselves as well. Because we have some new faces in Gary and Jessica and Michael that you probably haven't seen. So starting with Gary.
Of programs at CCADV. I'll be overseeing law enforcement activities, legal advocacy, and eventually training. I am a retired captain from the Middletown Police Department and former director of community engagement from the Community Health Center as well.
Hi, everyone. Jessica Sedlowski. Hi, everyone. I'm Margaret Day. I'm the Director of Law Enforcement Services.
I'm Michael. I'm the legal project manager. I'll be part of the subcommittee on the offenders.
Great, thank you. And then I apologize. I'm going to move back to Zoom really quick because I think Captain LaRock just joined as well. So if you want to just introduce yourself quickly. Right. Okay. When you have the technical ability to, that would be great. Okay, moving on in the agenda is the approval of the May 28th meeting minutes. Do I have a motion to approve the minutes? Thank you. And a second? Or any edits, questions, concerns before we move to the second? Okay, hearing none. Do I have a second? Great. Representative Nuccio, thank you for seconding. All in favor? Great. All opposed? Any abstentions?
I will have to abstain. I was not present.
Okay, thank
I
you.
abstain as well.
Okay, Gail and Johanna. Okay, great. All right, okay. The first item on the agenda is just reviewing the updated policies from the Division of Criminal Justice. I apologize that these were not necessarily in your packet, but I am going to send those out as Gail gives an update on some of the progress that the Division of Criminal Justice made regarding arrest warrants and successful completion of programs regarding some of the domestic violence offender standards programming that we worked on this past year. So Gail, you have the floor.
Good afternoon again, everyone. As you all know, one of the first issues that we tackled when forming this board was how to deal with the arrest warrants. We had received information from local and state police that when they apply for arrest warrants in domestic violence cases, that they sometimes go into the prosecutor's office and law enforcement doesn't receive any notice about when that warrant is going to be reviewed, signed, and how to get that warrant back once it is signed. In some cases, the prosecutor or either the judge will have questions about the warrants, or the prosecutor may deem that updates are necessary or further investigation is necessary. So the Division of Criminal Justice had to decide how we're going to address that. And we did that in our policy, we did that in our training, and as Megan indicated, we have provided those documentations concerning our policies to the co-chairs of this board. And she will be forwarding them, but
I just sent them out.
Okay, thank you. But in our division policy that is listed as policy number 520, we have a section on warrants, risk protection orders, and ex parte orders. And with respect to arrest warrants, our policy spells out all of the responsibilities of prosecutors when they receive an arrest warrant. It's required that they note the date the warrant was received, the name and date of birth of the accused, the name of the affiant of the warrant, the law enforcement agency that submitted the warrant, what charges are alleged, and the name of the reviewing prosecutor, and the date that that warrant was referred to the prosecutor. In those cases where the prosecutor is signing the warrant, the prosecutor is required to indicate their name and the date that they approved that warrant, and they're required to enter that information into our case management system. And once the warrant is reviewed and signed by the prosecutor, it thereafter goes to a reviewing judge. If that arrest warrant has been rejected by the prosecutor, the date that the prosecutor rejects the warrant and the prosecutor's name is also required to be entered into our case management system. If that warrant is approved by the prosecutor and submitted to the judge, we are required to indicate which judge that warrant was submitted to. And we also entered that into our case management system. If the warrant is approved by the judge or if it's denied by the judge, the date of that action and the name of the judge is also required to be entered into our case management system. And as we also took up by this council, there are times when a prosecutor is asking for additional information. In those cases, the prosecutor is required to note the date that they notified the police department about the need for a correction and or the changes that are required to be made or the investigation that is required. We note what date they picked that warrant up and what date they resubmit that warrant. We've always had open engagement with our law enforcement officers, so we invite them to sit down with us so that we can explain the changes that, the changes that need to be made. Again, I think it was Merritt LaJoy who brought up a warrant service that had taken place in Bridgeport. It was immediately upon the forming of this council, and there were concerns that a lot of those warrants, arrest warrants, were old. It was a warrant sweep, and there were concerns that a lot of those warrants were old, and we know that that our victims and our complainants can be negatively impacted by a warrant that either sits in a prosecutor's office or in the police department without service. So those are things that on the local level, within the 13 jurisdictions that our training has impressed upon the supervisors to make sure that your prosecutors who are handling domestic violence cases are ensuring that there's a timely service of warrants. And I believe that that's a concern that has been taken up by our model policy subcommittee.
Okay. Thank you, Gail. Any questions? Okay. I will also just note for those on Zoom that Mark Pelka just got here. So, hey, Mark, how are you doing? Any questions for Gail? And I apologize, I did just send out the form to your email, so you actually do have both of the forms that Gail was referencing.
If I could, Gail, just a quick question. You were talking about all that information, that tracking information will be uploaded into the state's attorney database. Is that the e-prosecutor database?
Yes, it is.
Okay, so that will be available. I know they take it into courtrooms and into judges' chambers. All that information will be available to them at that point, correct?
Yes.
Okay, all right, interesting. Thank you.
Great, thank you. Any other questions? Okay, I just want to say thank you because I know that was a lot of work in the subcommittees feels like it was just yesterday, Gail, but it was last year, the last year of the subcommittees in the council. So if no other questions, I'm going to move on to the next agenda item under A, which is law enforcement model policy. And Chief.
Good afternoon, once again, ladies and gentlemen. I have the advantage of being able to be brief. You will recall that we had previously submitted to the group our recommendations, and as memory serves, they were already voted favorably upon. Our work over the course of this last cycle focused largely on two areas. The first was the adoption, the mandatory adoption of the lethality assessment program into the law enforcement model policy. This was not a heavy lift because we had everyone doing it anyway. And that's not minimizing the work that we collectively did. It's actually rather a source of pride to me, and I think to us, that we had a scattering of law enforcement agencies throughout the state that appreciated the value of what that brought to the table, and that they had adopted it before it became mandatory that they do so. However, we thought that by formalizing it in the policy, there certainly would be no pushback to continue to do something that you were doing, and we would memorialize that as a requirement. We also detected in what was Roman numeral 10 of the policy that the weapons surrender compliance protocol that everyone or almost everyone was operating under had been memorialized into a memorandum of understanding, a memorandum of agreement. However, that was in the neighborhood of 15, 20 years old. And as with many other things that do not then thereafter become formalized in an overarching document, some of the protocols were not always followed by every agency. So we took the liberty of taking what should have been and largely was the standard practice and moving that into the model policy to make that a mandate as well. The last piece of what we did was simply the development of some language as to arrest warrant service. And we were pleased with it, but the more that we worked on it, we realized that we had slightly overstepped our bounds, and we lateraled that football to the honorable folks on our partner committee for their consideration. Thank you.
Thank you. Any questions for the chief? Okay, I do want to take a moment to acknowledge that everything that you did on law model policy is really significant to survivors and their families. So I know you already have been doing LAP, but it's such a critical tool that I know as advocates use daily. So to see it as a minimum standard is amazing. And I know it means a lot to me. I know it means a lot to Karen on the committee, and certainly a lot to the rest of the CCADV staff. So thank you very much for all of your work to do that.
Thank you.
And thank you to the law enforcement folks for carrying out that really hard work when you go to a call and have to do those assessments and ask some of those tough questions. So we're really, really proud of that. So thanks for all that you did on that committee. All right, hearing no questions, I will move to arrest warrants and orders of protection. And it's back to Gail.
And my co-chair is virtual, so if I miss anything, Shauna, please jump in. One of the things that we had been working on over the past month or the past few months has to do with getting Darren Mitchell to come back and to assist us with our firearms compliance. We have been working with judicial in trying to develop a pilot program and locate a pilot site. We understand that this time of year or around August and September, our judges tend to rotate, and it's imperative not only that we receive the blessing of judicial, but also that the presiding judge for a particular location has an opportunity to sort of get up to snuff with what our pilot involves and whether or not it can actually be implemented successfully. So that is one of the things that we're working on in the arrest warrants and orders of protection subcommittee. We've had several meetings with our subcommittee with Darren Mitchell, and we've agreed that we will meet at some point in September with our judicial officials and try to ferret out all the issues and logistics. Other than that, I just reported on the arrest warrants, so I think that's where we stand. Ms. Harrington, have I covered everything?
I'll just add and to echo Chief Fox that we did vote as a subcommittee on the changes that the law model policy subcommittee made to the arrest warrant guidelines, which wasn't a document that Liza had sent out with the meeting invite, if everyone got a chance to look at that. It's just the underlying language under Roman numeral 5, recommended response procedures. Under the heading supervisor, bullet 4, we voted to agree on adding the language as soon as possible. And we also voted under Roman numeral number 6, arrest guidelines, heading warrant arrest considerations. The final 6 bullets were added with modified language, basically just to expedite the arrest warrant process, which we voted on as a subcommittee, and we're also looking to vote on as a larger council.
Thank you, Shauna. So, yeah, our next step would be to vote on the updated approved changes to the law enforcement model policy regarding processing of arrest warrants. So if folks want to take a minute or two, it is in your online packet as well as your in-person packet. If folks want to take a minute or two just to review that, and then I'll call for a vote. I'm gonna give about 30 more seconds for folks if they still need. Okay, I'm just gonna ask for a motion to approve the suggested changes. Great, great. Any questions, concerns, edits? Okay, I'm hearing none in person, seeing none online. So all in favor?
Aye.
Great, opposed? Anybody abstaining? Great, awesome, thank you. Great teamwork, subcommittees, nice job. Okay, moving on through the agenda. Subcommittee reports, offender intervention standards. Joe. Oh, Merritt, sorry.
Good afternoon. So we haven't met yet since our last meeting. We plan on taking up the family violence education program. I know that Joe is working on getting us some statistics for that, as well as we're going to be reaching out to DOC regarding their domestic violence program that they use. In light of the auditor's report, we're waiting. I know it's on our agenda next. So for some decisions to be made about what's contained in that report, we're waiting for other issues. So that's what we'll be doing.
Great. Any questions for Offender Standards Subcommittee? Okay, I'm not seeing any in person. And I don't see any online. So we'll move on to the next agenda item, which is to review the public auditor's report on DCJ's prosecutor-led diversionary practices for family violence offenders. So just as a clarification, for folks online and in the room, you have in the room, you have printed the summary, but you received online the full report. And for folks online, you have both the summary and the full report in your online packet. I don't know if folks want to start. I was just going to start going from the summary and just go down the 6 findings. Really just emphasizing for this council that 3 and 4 are issues that this council will have to address. But certainly anybody can ask any questions about any of the other findings, as we do obviously have representation on the council for those. So number 1, anybody, I'm not going to read them out loud. I'm just going by the findings. And if folks have questions, concerns, things that they want to raise, that sort of now is the time to ask those questions or raise those concerns. So finding number 1, finding or recommendation, open for discussion.
Megan, I think I'll begin. And on behalf of the Division of Criminal Justice, when we received the findings of the state auditor, we immediately went into action to try to not only address what the auditor's concerns were, but to update our policies and to engage in training with our prosecutors to make sure that we were in compliance with the statute. And finding number 1 found that the Division of Criminal Justice did not comply with the NALI requirements for family violence cases. And what our Connecticut General Statute Section 54-56O states is that upon entering a NALI, for any family violence charge that is not referred to the judicial branch for intervention with one of their programs, the Division of Criminal Justice or the prosecutor is supposed to state that if the basis for the nollie was completion of a diversionary program or prosecutor-led diversion, that diversion or the counseling is required to be compliant with the standards, with the offender program standards. And in the Division of Criminal Justice's response, we indicated that we agreed with the finding. And as a result of our agreement, as I indicated, we not only made sure that we train our prosecutors to comply, but we've also we went through the process of updating our case management system so that we can ensure that we document our compliance with the statute. We also created a form that requires the prosecutor to make sure that they're informed of the offender program standards. So when a prosecutor is nollieing a charge and the basis for that nollie is a program or counseling that the defendant completed, the prosecutor is required to not only know who that provider is, but they are required to ensure that the counseling that the offender engaged in complies with the statute. They're also required to keep notes about the counseling that the offender is engaged in. And we know that with the different jurisdictions throughout the state, with 13 different jurisdictions, that things or the process can be different in different courts. By creating our policy, by creating the training programs to ensure that our prosecutors are complying, we can be sure that within the Division of Criminal Justice, every jurisdiction is required to comply by entering the information into our case management system and documenting in the notes. And we all know that when a case is referred back to the prosecutor because family relations is not taking that case, the basis of a nollie can be for a number of different reasons. A prosecutor in our court may receive information from a victim who no longer wants to prosecute or does not want that matter prosecuted. We may have concerns with the sufficiency of the evidence that was collected by police, but whatever the basis for nollieing a charge is, if it involves counseling, a prosecutor is required and a supervisor of that prosecutor is required to ensure that the line prosecutor has complied with our internal policies.
Okay, thank you. Any questions for Gail?
I do have a quick question. This may be off topic, and if it is, just tell me and move on. When you stated that you have the prosecutors inputting information on whoever the counselor was, can you elaborate on what type of information? Like, are you looking at licensing? Are you looking at whether or not they've signed an agreement? And if so, is that searchable?
Well, we are not requiring that the prosecutor look at licensing. And as we noted from the audit, that was one of those issues that this larger council is required to take up. I believe it's indicated in the report that there are um, eight providers and 14 individuals, and that this group or this council didn't necessarily have the authority from the legislature to approve or disapprove of a particular program. So when I say that the prosecutor is required to document the provider, the provider will be directed to what the standards are, and the prosecutor has to ensure that the counseling that that provider provided and that the defendant received was in compliance with the offender program standards. And so our case management system has a link to what those standards are.
Okay, so I'm sorry, I'm just imagining like an in-court situation. Would it be verified through a letter provided by the provider, or is that what you're envisioning?
Yes, I mean, and we know, having been line staff in courts that, and we being in court, we know how this works. Defendant comes in and family relations indicates that they're not accepting the case because of past referrals or what have you. And then that case comes back to the prosecutor in open court. The judge will usually indicate, are you going to, family's not accepting your case, are you going to apply for the public defender? Are you going to retain your own attorney? And what usually happens is that the defendant will receive some assistance from your offices, the public defender's offices, or the social workers from your offices or a private attorney to locate a provider that is in compliance with the statute. Defendant will be given a court date to come back and to show proof that they're engaged with a provider, and that they're engaged with a provider that meets the standards. So when they bring that letter back, it's envisioned that that provider will indicate, yes, I've reviewed the standards, and the counseling that I provide will, be over the course of X number of weeks, and these are the areas that we'll cover. So it's not going to be on that first court date. There may be a couple of continuances before the person is able to get into an approved program, but we are not going to do that approval. I think it's an issue for this group.
Okay, thank you very much. I do have other questions, but I think they are more related to what we're going to discuss further on. Thank you.
Okay, great. Any other questions for Gail? Okay, well, I think that actually kind of lended itself well to the other findings, right? In terms of findings 3 and 4. So for folks that haven't either read the full report, there were two findings regarding our council and what our jurisdiction or lack of jurisdiction is around the domestic violence treatment providers and the ability to approve them and monitor them and ensure that they are meeting the standards set out from the subcommittee. So I mean, just to full disclosure, obviously we had to provide a response. Myself and Senator Flexer had to provide a response to the auditors, and we agreed with the findings. We obviously don't have the resources or the ability to go out and monitor and do site monitoring and all the things that were suggested in the auditor's report. So we did agree with the findings that we obviously don't have the resources to ensure that the providers that are on the approved list are meeting all of the standards all of the time. And we also acknowledge that there are not very many. And I think that was one of the points of feedback in the report as well. So their suggestion, the auditor's suggestion, is to advocate for legislation to establish a specific approval process and oversight mechanism for community domestic violence treatment providers, and then also advocate for legislation to grant council or an appropriate state agency the authority to review and approve community domestic violence treatment providers. And this council didn't necessarily disagree with any of those recommendations, but certainly want to open it up for discussion. Okay.
Yeah, I'll go then. So is this something moving forward then we'll be forming a subcommittee on to discuss, I assume?
So yeah, we actually have that on our next agenda item to talk about subcommittee structure and if we want to change any for this upcoming year. It could very well fit under the offender standards as it stands now, or certainly something that we can form a different subcommittee on. Yeah.
Okay, then my follow-up question to that, and my real question is, are we implementing the what the prosecutors are doing and being required to do right now? Are we implementing that now when we are at a place where we don't have enough providers and we are not reviewing providers? I mean, do we have a gap here where prosecutors are being required to verify what cannot be verified at this moment? Is that where we are?
I do think that's sort of where we are. I think the prosecutors, from what Gail said, and I'll certainly let Joe speak to this, I think they're trying to fill the gap. You can tell me if I'm wrong, by saying these are the standards. Does this provider meet the standards? So it is like a self-attestation, unfortunately, in the interim, but I'll let Joe speak more.
I think that's how it's always been. I mean, obviously, when this was all contemplated, obviously the statute did not provide us the implementation authority. We knew that, but we needed to put something in place. And I think everybody around the table, which is pretty much everyone here, had a voice in that, and decided that what we were doing met the need. Obviously at that point, we hope there would be a long list of typical agencies and groups that have done that in the past, but we know that never came to fruition. I think that, there still exists law that says any provider that, undertakes domestic violence intervention has to follow the standards. And I think with the prosecutor, I'm not going to speak for Gail, but I think that having an agency or an entity say, yes, I'm following those standards, I think for them, I think that checks off the box. But what the auditor is saying is that there's a whole nother kind of state agency or some other entity that's going to take a lot of different things in play, including licensure and adherence to standards and how it's being implemented. I think that's a huge question mark. I think that our subcommittee, I would imagine, is going to be tasked with coming up with a recommendation about who would that be, and who would take that on. But then it becomes legislative. So I think it is going to be a process, and one that's resource dependent.
Right.
I don't think any entity is going to be able to say, oh yeah, we'll take that on, especially if there's a monitoring component to it. is going to be a really hard thing to do. And given that, from what I understand, is that once you go through a process like an RFP, or you're asking agencies to apply to something, that's a lengthy process. So I have a feeling we're going to probably be doing this in stages, knowing that it's not going to completely address the auditor's report. But at the same time, and I think one of the things that I know that we all tried to impress upon the process when they audited was that this isn't something that has been ignored for years. We've all known this has been an issue. We've tried to solve it over many years and many different venues, but to no avail. And it wasn't for a lack of trying, and it certainly wasn't something on the part of a prosecutor or the chief prosecutor that they were ignoring this. We were trying to find a solution. Bringing another state agency in, that's a whole different ball game. But I think we have direction from the auditor, and I think we can move down that path. It's just a question of how do you connect those dots so it meets the objective.
Okay, so just on behalf of my clients and so I could report back to our line attorneys, in the meantime, we're still sort of going along with what we've always had. We've had these requirements, and the state's attorneys are just going to have to use their best judgment until we as a group can figure something else out to recommend to the legislature. It's the in-between time that concerns
well,
me.
I think that the auditors kind of made their recommendations, and I think Joe's put it well, we as a subcommittee need to sort of take the report and say, okay, what's doable, like what's realistic, here's our recommendations. I mean, there's always the chance, we obviously have legislators on this council that they take these recommendations and do something else with them as well. And we can't necessarily control that, but I would imagine that, at least for the legislators on this council, certainly would be actively involved in whatever in that subcommittee and whatever would come out of that subcommittee. But yeah, for now, I think, Gail, I'm not going to speak for you, but they're trying to do the best they can with what we have. I mean, we're all trying to do the best we can with what we have. And then we'd have to obviously implement the changes as they get either approved, whether they're statutory or whether they're administrative, whatever that looks like. Yeah. Did you want to add anything, Gail?
No, I believe that covers it.
Okay. Okay. Any other questions, concerns that folks wanted to highlight or bring up on the auditor's report? Okay. Chief Rosado. Sorry, did I see you raise your hand?
I did, thank you. So I see that the report kind of reflects 2021, 2022, and 2023. And in order to implement some change, I think these audits and these summaries need to come out a little quicker. It's just my opinion. I think if we want to make some real impact or changes, I think audits should be done probably every couple of years at least, and more, obviously we're changing policies every year. And at the very least, maybe we could change some policies immediately rather than wait 4 or 5 years down the road. It's just my opinion. I'm not sure how we change that, but I'll leave that up to the board and up to you. Thank you.
Thank you. I do also want to acknowledge any questions or comments for Chief Rosado. Okay, I do want to acknowledge that Judge Doyle did join, so I apologize for the delay in acknowledging you, Judge.
It's not necessary. Sorry, I'm late, Megan. Don't worry about it.
Okay. All right. Any other questions, concerns, discussion around the audit before we move on? Okay. All right. I see none online. I see none here. So I'm going to move to the next agenda item, which Johanna beautifully forecasted for us in terms of subcommittee structure and participation. So we wanted to sort of open this discussion up for the full council. I think our co-chairs have some thoughts that they want to share, but certainly want to sort of talk about what this upcoming year should look like in terms of subcommittee structure and participation, and how folks are feeling about the structure and the participation, and if there should be any new subcommittees that are formed or any subcommittees that should be merged. And I know Joe has some feelings about this, so.
The only thing I would respectfully request is that I think there's a lot of overlap between offender intervention standards and arrest warrants. I know that many of our subcommittee members are also members of the other subcommittee, and just for efficiency, I think all our voices need to be in both of those rooms, and there's some duplication. So if I could make a suggestion that we have, I don't know what you would call it, maybe it's just a court subcommittee, just so that we all can be more focused on those issues as they come, especially if offender intervention standards is going to be changed dramatically. I think it should be put into one bigger subcommittee that is court related.
Great. Anybody have thoughts related to Joe's comment? Agree, disagree? I see some heads nodding.
I think it's something that we've discussed in previous meetings, and as Joe mentioned, a lot of us are on the same subcommittees, and it sometimes goes into back-to-back meetings where you're in a meeting with a small group of people, and then right after you click off, you got to click on to a different Zoom link to engage on that subcommittee. So for efficiency's sake, and because we are talking about the same topics, I think that Joe's recommendation makes a lot of sense.
Okay, great. Any other discussion around structure or participation? One of the things I'll just highlight is it is a hybrid structure right now. I want to gauge if people are okay with that. That does mean that any chairs or anybody running the meeting has to be physically present here. But that seems to be working for everybody. Okay. See heads nodding. Okay. Great. Anything else regarding the structure of the subcommittees?
I feel that the law enforcement model policy one should remain and should stand. I chatted with my fellow co-chair just a moment ago. As we sit here right now, I'm quite pleased to tell you I don't think there's any changes necessary, because if there were changes necessary, we would just finished making them. But next week, next month, when something pops and we collectively say we didn't think of that, there's a big piece of this that falls back to law enforcement. So I would advocate for the retention of that one as it stands.
Great. Okay.
The only other thing I would suggest is maybe asking the bigger committee if anyone wants to participate in the subcommittees. We did that like one time, and I'm not sure if it would make sense to put out an email that says who wants to join some of the subcommittees. I think that more voices are necessary. I think that some of the subcommittees, at least ours, it's really the same people with the same voice. So adding more participants would be very helpful.
Great. Yeah, we can send that out with the start of this new year and have folks sign up. That was a good suggestion. Any other suggestions or comments, things that you want to see changed? Okay. I don't see any online. I'm not seeing any in person. I do think there's one in item B that we should talk more about. It was our first year this past year. So I think we were flying the plane and building it, to use that analogy. So I do think some of our recommendations that wound up being legislative proposals, I think we want to sort of try to make that process a little bit smoother, have that process be more collaborative and transparent. So I think one of the recommendations is if and when there are any recommendations that come as in the final report, that at some point in that process, when the subcommittees have their reports that they provide to the full council, that each of the agencies or entities involved then start to engage their legislative liaisons, and maybe those folks start to meet collectively first before we get to the final report phase, just so that we're all on the same page in terms of language and that they can stay in contact throughout the legislative process. Because obviously we all know that language can change based on a lot of different circumstances. So just trying to keep people up to date on that. I think we're going to try to do a better job of that moving forward. But anybody else have any suggestions around this process? Okay. Mark, yep.
I arrived late too. I was wondering, do you think the advisory council could develop a list of the recommendations and what was enacted and what public acts? Has that already been done? I'm so sorry if it has.
No,
But
actually,
it occurred to me that,
yeah.
you know, there are multiple, it was unclear what vehicle was going to be for the legislation. So I tried to track different things, but it occurred to me
Yeah.
that I didn't know the final outcome.
Right.
And maybe for future meetings, that would allow us some other reflection of what outcomes were.
Good suggestion. The good news is there was nothing that was enacted legislatively. I don't know if that's good or bad news. One of our bills died at the last minute. So I think we're all going to make sure that that doesn't happen, and we're all going to get together and work on the language and make sure we're all on the same page. That was the supervised diversionary recommendation for folks that may not have known. So
What bill was that died?
it was the supervised diversionary program, the update around mental health and yeah. So I know that Merit and others are going to work to get everybody on the same page about that this legislative session. But yes, good point. We will come back with progress. I do want to shout out the law enforcement model policy because all of their recommendations did get passed and enacted. Now, granted, they didn't have any legislative necessarily, but everything did get done. And I think Karen wants to give an update on that in terms of timing when that will roll out to law enforcement.
Definitely like to thank the full council as well as the subcommittee, because we need to meet often early to get onto this new calendar that allows us to have this passed in July that caused the full council to have to come together to do that. I think ultimately it is going to work better for law enforcement, giving them the heads up on the training. It also timing wise gets that information into their handbook, their red book that they keep in their car. So they'll have those best practices all the time and in a timely manner, because they were coming late and then it was never up to date. So thank you to the subcommittee for meeting pretty rigorously and getting the work done. And then thank you to the full committee for letting us kind of switch up our calendar of how we're doing business.
Yeah, no problem. Okay. Well, that's a good segue too, because our next item, if there's nothing on legislative process, and we will certainly check in at each full council meeting to make sure that people feel like they've gotten the proper information, that they are up to date. If there's anything coming down the pike from any of the subcommittees that might involve their legislative liaisons or whoever is handling their policy. But timing of the 2025 report, I know that seems crazy that we're talking about January, but our next report is due January 15th of 2026. So that really means that the draft recommendations from the subcommittees have to come to the October 1st full council meeting. And then the draft report content, that means like your similar to what you all did last year, your summaries and your findings. All of that language has to be to the full council by November 15th. November 15th. So I know that seems far away, but it actually is going to creep up on us, I think, pretty quickly. So that's just sort of a heads up to the co-chairs and this leaders of the subcommittee. Obviously, you'll structure and find the meeting times that you all need for your recommendations. But I just wanted to flag those timelines for everybody. Any questions regarding the timeline? Okay. All right. I don't see any. Okay. So, moving on to other business. Okay, I do have a fun other business, and if there's any other July birthdays, join in. But I just learned that there are multiple July birthdays in the room, like Merritt, Joe, Gail. Who else has got a July birthday that I didn't know about? Karen, anybody online? No? Are we Cancers? Are we Leos? Leo. This explains a lot about this council. I think almost, I'm not a Leo, but all these guys are. Okay, so I just wanted to wish them happy birthday. We had a pretty large contingent in July, so figured I'd give them a shout out. And then the only other piece is October 1st is the next full council meeting. So plan your subcommittees accordingly. And then I just ask for an adjournment. A motion to adjourn.
So moved.
Great.
Second.
Awesome. All in favor? Great. Have a good rest of your summer. Enjoy it. Bye.